For today's question, we ask, must a state permit religious exemptions to the COVID-19 vaccine? Stay tuned and I'll give you my color of law. Today's case takes us to Maine. Until 2019, the state legislature of Maine had 3 different exemptions for vaccination requirements that pertained both to the people in this case, which are healthcare workers, and school children. Those 3 exemptions were a medical exemption, religious and philosophical exemptions, or a sincere religious or philosophical belief. This takes place in the state of Maine. Until 2019, the state legislature had exemptions in statutes for vaccine requirements. Those exemptions were medical, religious, and philosophical. In 2019, however, which predates the COVID epidemic, the Maine legislature enacted legislation that struck from the legislation religious and philosophical beliefs. Under Maine law, the only exemption now for vaccine requirements relates to medical-based exemptions. In August of 2021, the relevant state health authority put on the list of mandatory vaccines the COVID-19 vaccines, and also extended the level of coverage to other facilities, such as dental practices and emergency services organizations. So Maine, like other states, including California, have banned religious exemptions. Is that something a state can do? So to understand that, we have to understand the federal law when it comes to the free exercise of religion. The Free Exercise Clause establishes that Congress and the states, through the 14th Amendment, shall make no law prohibiting free exercise of religion. The Constitution's Free Exercise Clause does not prevent states from enacting a neutral, generally applicable regulatory law, even if the law infringes on religious practices. And this comes from a Supreme Court case called Smith, which is the dominant case along with Lemon when it comes to these kinds of rules. Laws that are deemed both neutral and generally applicable are subject to a rational basis review, which is very, very easy to meet. The Supreme Court in Smith wrote, "We have never held an individual's religious belief excuses compliance with otherwise valid law prohibiting conduct a state is free to regulate. The record of a century of free exercise jurisprudence contradicts that proposition. If prohibiting the exercise of religion is not the object of action but merely incidental, the First Amendment has not been offended. But on the other hand, if a law burns religious practice and does not satisfy requirements of neutrality and general applicability, the law is invalid under the Free Exercise Clause unless it survives strict scrutiny, which is basically impossible to meet." So the relevant question when it comes to state law is the question of whether or not this is a neutral regulation, burn religion, or treat religion separately. So that can be happening on one of 2 levels. Obviously, the statute on its face can do that, or the statute in sort of its practice can do that. So you look to whether there was animus against religion as part of that and see if that was a motivating factor, which is also what we learned from Masterpiece Cake Shop, for example. When animus against religion is the problem, then you have a religious-based discrimination, even if the rule is facially neutral. So the question is, was this a religious-based discrimination? Under rational basis review, as it regards the state of Maine, the foundational case is Jacobson versus Massachusetts, which we've discussed on this channel before. And the court upheld the constitutionality of a state-mandated smallpox vaccine. The court applied a differential standard of review and rejected the 14th Amendment challenge, concluding that mandatory vaccination laws were constitutional because of a real and substantial relationship to protection of public health and public safety. So in this paragraph, we do learn a key factor, a factor that has to be understood as we will evaluate COVID mandates coming from the federal government. The states and federal governments are in different postures. The states have residual powers, called police powers, the general power to do stuff. And the United States Supreme Court has ruled this general power to do stuff includes the power to regulate health. In Jacobson versus Massachusetts, a case which is questionable, but still good law, they ruled as to state-level authority because of this residual power. But as it applies to national mandates, we have to have a whole separate set of analysis. So Jacobson, while informative, may or may not be that helpful when it comes to the Biden mandates. But as to what Maine wants to do as a matter of state law, much more helpful. So yeah, Maine can mandate vaccines as a matter of state law. That's what Jacobson teaches us, at least in part. Yeah, Jacobson was pre-strict scrutiny, that too. So Jacobson is not within our traditional framework because the framework hadn't been invented yet. The court goes on to write that the COVID vaccine mandate here is facially neutral. The statute nor the rule mention religion, even by implication. They require that all healthcare workers employed at designated healthcare facilities receive the vaccine. They do not treat the vaccine any differently from any other vaccine also mandated under law. The vaccine's facial neutrality, however, is not necessarily dispositive, because even if a government acts neutrally when it proceeds in a matter, if it's intolerant of religious belief or strict practice because of religious nature, the facial neutrality is not enough. A facially neutral law may not survive if its object is to discriminate against religious basis, beliefs, practices, or motivations. So the courts are not that dumb. If a statute or regulation does not mention religion, then they can still look to whether or not there is discriminatory intent or discriminatory purpose for it. Which is what Masterpiece Cake Shop, for example, tells us. If you can show the rule is facially neutral, but either as applied or otherwise is animus to religion, then you have a free exercise problem. The court goes on to compare to a New York regulation that court went the other way, and compare it to the COVID mandate in Maine. New York's regulations originally provided for a religious exemption, but it was removed only a few days before the requirement became effective. New York provided religious exemptions to other mandated vaccines for healthcare workers. So in New York's case, the timing was different. They allowed religious exemptions, but right before the COVID-19 mandate went into effect, they tried to remove the religion. So that could show an animus to religion, because they're treating the COVID-19 vaccine different. We would have allowed religious exemptions, but we're not going to anymore because religious people might object to the COVID-19 vaccine. So the timing can infer a religious animus. But Maine didn't have that problem because Maine passed its rule in 2019, which is before COVID existed or was even thought of. So it can't be based on any particular religious animus to who the COVID-19 vaccine will get. So the timing was different. In New York's case, it was a religious gerrymander. But in Maine's case, they removed it for all vaccines well before any reason to do so, which is also true, for example, in California's case, which also removed it well before the COVID-19 vaccine was conceived of. So those timings do not suggest a religious animus, unlike what New York did, or maybe other states did. The court notes that the vaccine mandate promotes public health, and not all the exemptions are so related. While an exemption for medical reasons also promotes health, namely the health of the individual person, not the same can be said for the philosophical or religious mandates. Philosophical and religious mandates do not relate to physical health, either of oneself or the public at large. So the exclusion of philosophical and religious mandates is in a different category than the medical ones. Medical mandates are compatible with, if not even necessary, to the overall purpose of promoting health. By granting the medical exemption, we promote the personal health of the person getting the exemption, and therefore contribute to the overall purpose of the vaccine mandate. But not the same can be said for religious or philosophical mandates and exemptions. So those exemptions can be thrown aside while remaining compatible with the overall purpose for which the vaccine mandates are triggered. Thus, the court rules that the vaccine mandate in Maine is facially neutral, and recent Supreme Court cases dealing with COVID-19 mandates do not say otherwise, because those cases dealt with situations in which religion was being treated worse than secular counterparts, which isn't the case here. In looking to potential animus-based reasons for the exclusion of religion and philosophical exemptions, the court notes the state's motives in establishing these removals occurred in 2019 when the statute was passed, and does not occur in 2021 like the New York statute is in effect. The plaintiffs have not offered any explanation of how the COVID-19 vaccine mandate could be viewed as targeting religious beliefs when the relevant exemption was created at a time the COVID-19 vaccine did not yet exist. The record establishes that Maine's objective in eliminating religion and philosophical exemptions was to further critical health goals, and does not establish any animus towards religion, unlike the New York case, in which the timing of which is more suggestive. The medical exemptions applicable in Maine to the COVID-19 vaccine and other vaccines required by Maine's law do not reflect a value judgment unfairly favoring secular interests over religious interests. As an integral part of the vaccine requirement itself, the medical exemption for healthcare workers does not undermine the vaccine's mandate's general applicability. Now it's time for my color of law. As to the Maine law, I give this court analysis level blue, reasoned. The court's decision is compatible with the law in place. It's compatible with Smith because the court finds, and there's no reason to think otherwise, that the legislature's intent in 2019 was not on its face or for any other motivation based on religion. It was based in overall health and as compatible with other states that have done so. But New York is different because of the particular timing, which isn't present here. The court also relies on Jacobson, a case that is questionable both for when it was decided and the fact that it was decided outside of the current constitutional structures in which we consider such cases, but nevertheless is a binding U.S. Supreme Court case. So when it comes to state-level authorities, and Jacobson does seem to imply this result, I, more than anyone, have been overcritical of Jacobson's application in state-level law, but in this particular instance, I find this to be a fair application of Jacobson, unlike many other cases in which I've criticized this application for going beyond the scope of what Jacobson was talking about. This is much more on point. So, as to Maine, it seems quite reasonable for this court to say that yes, medical exemptions are still fine, but religious-based exemptions are no longer okay, and there was no religious animus here, thus leading to level blue, a reasoned analysis. That brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.